Hi, and welcome back to another episode of NCBA's Coffee Break, where we tackle big legal changes in small window of time. I'm your host, Nathan Willner, and today we're joined by someone who's had a very eventful few weeks in the legislative arena, attorney Lauren Keating from the New Jersey Creditors Bar Association. Lauren, thanks for being here and taking a break from reading, I guess, emergency pieces of the legislation throughout the state of New Jersey. So welcome.
Thank you.
Let's start with the basics. Can you briefly share your background and what you do and your role within the New Jersey Creditors Bar Association?
Sure. My name is Lauren Keating. I'm a partner with the law firm of Lyons, Doughty Veldhuis. We are a consumer debt collection law firm, an NCBA partner. We're a multi-state practice based in New Jersey, which is where I live. And at LDV, I am the director of litigation, so I supervise all the attorneys in our various states, and I also keep an eye on our state legislatures, which has been keeping me pretty busy recently.
Yeah.
With the creditors, with the New Jersey Creditors Bar, I've been working with them for about 10 years, going out and working with our members as well as our lobbyists to try to educate our friends in Trenton about our industry.
So that's a lot of work, and you're keeping yourself obviously very busy. Um, so we're going to talk about a certain piece of legislation. Let's start at the beginning. How did you first become aware of the Veterans and Military Spouses Asset Protection Act? And more importantly, how quickly did you realize it was moving faster than the morning commute on the turnpike? I mean, things were moving really fast. How'd you find out about all this?
We found out about this during a lame duck session in the New Jersey legislature and during the holiday week. So I think it was literally New Year's Eve, maybe, when we caught wind of this. Our lobbyist sends us daily periodic emails of any bill that's dropped that affects our industry and the status. And this one had moved out of the Senate very quickly and only came onto our radar when it was pending in the Assembly. At which point we realized we needed to get some meetings going and make sure we had presence at the Assembly hearing that was going to be coming up.
So, for listeners who haven't had the pleasure of reading the bill verbatim, in plain language, what does the act actually change regarding exemptions for veterans and their spouses?
Well, the act creates a whole new category of people, which are veterans and their spouses, and provides them with an exemption of not only their primary residence, but also a secondary piece of property within the state of New Jersey, and fully exempts, no amount, not capped, fully exempts those two pieces of property from levy, execution, attachment, or forced sale.
Hmm. So, something that caught a lot of attention is just how broad this bill is. And what makes this exemption unusually wide-reaching is the fact that there's no means test, no requirement that the debt be military related. And because when attorneys say something is broad, the rest of us know that's code for things are going to get complicated.
Really complicated really quickly because you have also this introduction of spouses. How do you know who someone's military spouse is? We're not able to search veterans, first of all, on any widespread database that's known to the industry. And then finding a spouse, then you're talking about someone who incurs a debt and then a few years later becomes a spouse. It was really broad, not to mention the lack of means test. You know, New Jersey is home to many reputable, high income veterans, millionaire veterans.
Yeah, so I guess there's a certain perception people think of veterans, that are just coming out of the military, maybe, you know, be financially challenged, but that's not really in this case. It could be someone that was a veteran who knows when, and it's not even tied to their service or anything of that nature. Isn't that true?
Yeah, and that also made it really tricky. We'll get into this a little bit, but it was really tricky to speak publicly, a quote unquote against a veterans bill. You know, we're humans, we're citizens, we're veterans. Many of our members, our lobbyists, we're veterans, pro-veteran, obviously, but when you have to walk that line between supporting a population, but also having legislation that's logical and sensible, it can be a little tricky. So that was one of the challenges with advocating for our industry in this context.
Yeah, no, absolutely. I mean, we're all very proud of, the the men and women who wear the uniform and serve our country. And I think this is just one of those examples where, you know, legislation is a one size fits all, and but that's not really true. And this is one of those cases where I don't think anybody's saying that there aren't, special, needs of veterans that we need to be sensitive to. We're just saying that having it in a broad way, one size fits all, is just sort of unfair and unintended. And then there's all these consequences.
Right. I mean, we in New Jersey have a very large veteran-owned business community, and they actually probably stand to suffer more as a result of this legislation as business owners. It's tricky. It's hard to make everyone understand all the sides of the equation, especially in a
Yeah.
short period of time. Like I said, this bill was moving quick.
So then there's the question of no one wants to be the first to kind of test it. Do you expect like early litigation on whether liens can still be filed and simply, can it be waited on since the law doesn't expressly forbid it? To see like who blinks first.
Yeah, I mean, we have a pretty active plaintiffs bar in New Jersey, so it is a question of just this loose drafting, that the prohibition is on levy, execution, attachment, or forced sale. Well, a judicial lien is none of those things. Those things are all legal constructs which are defined, and a lien is also a legal construct which is defined. So absent clarity to that point, we can expect litigation. We also, once it's passed, we informed our clients that this exists if they want to create a policy around it or they want our advice how to handle. If someone were, it's not only litigation, but it's also someone invoking a right sort of under the statute and how do they want us to handle their cases in that context.
Yeah, and because there's also, that reputational risk, like we were talking about, anytime we're using, very charged words like veterans, and that brings certain emotions, you want to be careful and be able to really explain what we're talking about and how this affects any population, any consumer population when we're talking about creditors' rights. So I know that you were directly involved in this kind of legislative conversation. And since most of our listeners are attorneys, how does advocating for legislation for a bill in a state legislature differ from when we're in front of a judge advocating on behalf of a client?
I thought that was a good question. Nathan did send me the questions in advance, so I got to think about that one a little bit. And I kind of came up with the idea that it makes court look like checkers and the legislature is chess. So in court, it's you and the judge. Most of our matters don't go to jury trial. So it's you and the judge. And these are judges, your entry level court, so to speak. In New Jersey, it's a superior court, a court of common pleas type court. They're bound by precedent. They're, for the most part, not activists, and they just look at your facts, your case, and you advocate for your client, and that's that. In the legislature, you have the member, maybe who you're meeting with privately, or if you're testifying in front of a committee, you have several members, and they're thinking about their constituency, they're thinking about someone who sponsored this bill, who they like or don't like, or who they're working on something else with, and they want to move this forward because they have an association to another bill or two other bills. It's so multi-layered. There's so much going on, and that's why I think our New Jersey Association has really benefited from the longevity that we have and that we continue to build on, just getting to know the members, getting to know how the pieces all work together because unlike court, there's a lot beneath the surface. It's pretty much all beneath the surface.
Yeah.
So that's a big difference in just the expected outcome. I mean, the practicality is not very different. You're speaking before a public audience, you're prepared, you're expecting questions, you plan for the questions. Practicality is fine, but the outcome is very, very different.
Yeah, and I'll never forget the first time that I testified before a legislative committee. Uh, it dawned on me that some folks were less than honest, and I realized that this is way different than court. First of all, there's no rules of professional conduct that say you have to have candor before a tribunal. And then further, like when you testify, you're not under oath, so it's not under the penalties of perjury. So basically, when I've spoken to legislators or lobbyists, they push the envelope pretty far because their adversaries do it as well. So it's a whole different language being spoken. And while it looks like a formal proceeding, like a court, it has the same kind of wood paneling, it looks sort of like a courtroom. Boy, are the rules different. So I know you testified before the Assembly Judiciary Committee. How'd that go? What was your experience like?
Yeah, just piggybacking on that, in that experience, they ask us to read a 3-minute statement. So in court, obviously you don't want to waste the court's time, but you can speak as long as you think it takes to get your point across. In here, 3 minutes, they had a bunch of bills to be heard. You're welcome, Miss Keating, you have the floor for 3 minutes. That was that. So, we really had to be careful about our words. We obviously prepared the statement in advance. We workshopped it with our lobbyists. We submitted it to the committee in advance. Um, the experience was interesting because actually on the day, another very hot bill was being heard that had a lot of community interest regarding how ICE engages with the public. And there were hundreds of people in the hearing room, so much that they had an overflow room. So, of course, this bill, as Nathan and I talked about earlier, we're trying to be sensitive to this Veterans Committee. You just knew that in front of these wide group of constituents, these members were not going to, it was going to be very hard to have them publicly go against the veteran community, even though we were trying very hard to explain that we supported the bill if we could narrow it and make it have some reasonable guardrails and something that we could work with. Um, but I kind of got the sense early that it was a tough room for our position. I still spoke. They asked a couple of questions. It's interesting. One of the members was an attorney, so she had a little bit of understanding, awareness, possibly empathy over the question of how can the courts even enforce this when we don't have a way of identifying this population. So, if somebody doesn't answer a complaint and identify themselves as a veteran or a veteran spouse, we don't have a database. The DoD database does not identify veteran spouses. So how are we supposed to comply with this? Even, if we're going to say, sure, great bills, we're all on board for the bill. How would one even comply with this when you're running a large volume practice, which is how the businesses in New Jersey are pretty much run? So, we're trying to, it was interesting. It was a little bit intimidating, but, I thought they heard me, but like I said, the writing was sort of on the wall when it came to the optics.
Yeah, because like, as you're saying, it's very much of different. It's not just the facts, ma'am. It's not that situation. There's a lot of spin. So as we're getting close to our end of our cup of coffee, so to speak, for listeners that want to get involved in state advocacy, what's your one piece of advice for professionals wanting to dip their toe in the legislative process?
I would definitely encourage everyone to reach out to their peers in the state. I think that is a good way to get together. There's obviously healthy competition in our industry, but we have to be able to reach out to our peers and work together when numbers is what it takes. Lobbying is very valuable, but it's also very expensive to have a lobbyist on retainer. We've found that in New Jersey to be very worthwhile, but I think any one attorney would not be wanting to foot that bill themselves. So you need a coalition, you need your peers in the state, find out who's maybe been doing some stuff on the side, and then the legislature in your state is made up of lay people and professionals who might be in everyone's personal network. So kind of use the fact that our state practices are spread out to lobby and reach out and network amongst the different counties or jurisdictions where the legislatures are based, and build a coalition amongst your peer firms.
Yeah, that's great advice. And the reality is, legislators are much more interested in hearing from you than you might think. And it's not that hard to, uh, set up a coffee or whatever. And it's something that pays off when you need that relationship. The time to find that person is not when there's a pending bill. That's not the
Right.
time, to say, hey, So, Lauren, thank you again for joining us. And this has been really great. And I'm really proud of the work you're doing in New Jersey and the Jersey Creditors Bar. And of course, NCBA is here to support the work you're doing. So, any of our listeners, if you're in your state, you need help, please reach out and we'll see what we can do to mobilize our troops to support the work you're doing. And for our listeners, keep an eye on this law as it rolls out. And I'm sure if anything changes, Lauren, you'll keep us posted, and hopefully you'll come back and talk about some other legislation that's going on in New Jersey, which is another whole boondoggle. So that's New Jersey. I guess it's not our cup of coffee wearing off. New Jersey will just be New Jersey, and it's a lot of work keeping things straight. So anyway, thank you everyone for listening. Thank you for being engaged in NCBA and everything that goes on in the creditors' rights world, and have a great day, everyone.